Good morning,
Good
Mr.
morning.
Pence. Just so that I follow exactly what is going on here, your application deals with attorney's fees, correct? No, long
No.
way. Oh, I'm so sorry.
This is Mr. Kirsch.
I didn't even. Okay, all right. So I've got.
Mr.
I get
Bodoff?
wonderful little instructions from my normally
all mislabeled.
extremely competent clerk. Okay, so you are. Thank you very much, counsel. So let's just. So you are representing Mr. Scott, the trustee,
Yes, Your Honor.
correct? And they're really they're two big pieces here, correct? The one is the piercing the corporate veil, and the other is the attorney's fees, correct?
Yes.
Okay, now I don't want you to be treated unfairly because you apparently are going first. So, depending on how many questions, which piece are you going to tackle first?
I'm going to tackle the piercing the corporate veil part of it. The attorney's fees part of it, we're prepared to rely on the briefs.
Okay,
There's
fine.
not much for us
That's
to say
fine. I just
about.
didn't want to find that we were hammering you on one point or another and taking time, so that we will try, if we have particular questions about attorney's fees, we will address those to you, but we will at least try to start off by focusing on the piercing the corporate veil, okay?
That'll be fine.
Thank you, and good morning, Mr. Bodoff.
Good morning. This case has come up to this court after the appeals court reversed the grant of summary judgment by the Superior Court in this 21E case. The appeals court held that there was, in fact, sufficient evidence to withstand a summary judgment motion and has ordered the case down to the Superior Court for trial. There are a couple of points to keep in mind. That the facts of this are, to say the least, complicated.
Put it mildly.
After a number of readings, I could probably boil it down into a number of relatively simple.
It'd be nice if we
Events.
had a chart, I don't know if there's one in the record, that traces these corporate, maybe there is, traces these corporate sales, mergers, and so on and so forth, consolidations, splittings, and found a clean line between Salem Gas and NG and Boston Gas.
I think there are maybe not one chart, but I know that there's at least 3 charts in our brief that
Okay. Is
cover
this
that.
really a question about piercing the corporate veil, or is it just a question about successor corporate liability?
It's actually both. It's actually both. I bought into the piercing the corporate veil more as a
Because
generic type
those
thing.
concepts are different.
Yes, they are. And in the piercing the corporate veil context, we're really talking about what I call the second prong of the my bread baking test, which is the confused intermingling and pervasive
Can
control.
I ask you a very simple question? You're
Yes.
representing the buyer of the property, right?
No, sir.
Yes, the owner.
The
Oh,
owner,
yeah,
right. Why didn't you have an environmental inspection before you bought the property? Or did you?
I don't know. I don't know the answer
I
to
mean,
that.
that would have solved this whole case.
It might have, although as the appeals court noted or the Superior Court noted that certainly isn't a prerequisite for us proceeding.
I understand that,
Oh, and
right? Today knows about 21E liability, I would think.
I understand. I wish I could answer the question. I
Okay.
can't.
Mr. Bodoff, it would also be helpful for me to know when you're addressing whether you're doing it as piercing the corporate veil and or successor corporation, whether you're putting the corporate defendant, not Boston Gas, NG US 1, whether you're treating them as an owner or operator for environmental purposes.
I will address all of that. Let me see if I can simplify the history of this. Salem Gas Light Company operated a natural gas manufacturing facility at the property that is adjoining my client's property, and sold that property in 1890.
That's a property that begins with an N street, I forget.
Northeast Street.
Northeast Street. Right.
I believe it was in 1931, Nice acquired Salem Gas Light, and from that moment operated it as a division of the company.
Had the Northeast Street property been sold by
Yes.
that point?
The Northeast
30
Street
years
property
before.
had been sold. For a period of time between 1931 and 1951, this is how it was operated. And in 1951, Nice established a gas division that supervised the operations not only of Salem Gas Light, but of also its other 7 gas subsidiaries. The gas division was not incorporated, but the gas division, the president of the gas division appointed the heads of each of the subsidiaries that were referred to as managers. The record shows that the treasurer of Nice was in charge of financing for each of the gas subsidiaries and made policy decisions on behalf of the gas subsidiaries and made determinations as to what it could spend money on or how much money it could spend.
So as far as you're concerned, the line is pretty linear. It goes from Salem Gas to Nice and from Nice to NG.
Yes, except let me, yes, in one aspect of it. Then what happened is that in 1953, North Shore Gas Company was incorporated, and Salem Gas Light was consolidated into North Shore Gas Company along with, I believe, 2 other gas subsidiaries and maybe others. At that point, we have what I would clearly call, I don't know if the word successor liability or not, but North Shore Gas Company at that point clearly becomes Salem Gas Company in terms of the assets and liabilities. It acquired the assets. There's documents in the record that it talks about the consolidation. There's formal documents to that effect. Then going forward from 1953, in 1964, the SEC ordered Nice to divest itself of all of its gas subsidiaries, finding at the time that Nice was exercising pervasive control over these subsidiaries. It was one and a part of Nice. And as a result of that, I think there was an appeal to the Supreme Court, and that finally in 1968, the First Circuit entered a final judgment ordering the divestment. All of that resulted in a rather complicated transaction in 1973, which ultimately resulted in the sale of North Shore assets to Boston Gas, with a little interim step in there, which I can talk about in a second, and all of the money for that going into Nice's pockets.
Mr. Bodoff, let me interrupt you because otherwise your time is going to run and I really need to ask a couple of questions here. Let us assume that there's a straight line linking Salem to NG, US, correct?
Yes.
The claim here against Salem is not as an operator, is it? It's as an owner.
Well, you mean the claim against?
Salem.
The claim against Salem is both as an operator.
And how is it claimed as an operator?
We have taken the position that by the continuing storage of the waste on the property. It was operating in a storage
But it
capacity.
wasn't property owned by Salem.
It wasn't owned by Salem, correct? Salem divested of its ownership in the property in 1890-something, correct? It wasn't operating.
I understand. It wasn't operating a gas manufacturing facility.
It wasn't operating anything. It didn't own the property anymore, correct? Under classic environmental law, it wasn't an operator, correct?
It wasn't an operator to the extent that it was
It was an owner. It was a former owner,
certainly was a former owner of the property.
correct? And in what respect was it an operator?
We have made the argument, which has been rejected by 2 courts so far. I'm going to make it again. I don't think it's necessary to our case, but that it was operating to the extent that it continued to store waste
So I'm
from
not
the
asking you
facility.
to waive that argument, except to say I'm dubious about it, okay?
There's
It's
2 other
there.
courts that have been also.
All right, okay. If it's an owner, and if we've got straight down, never mind piercing, just successor liability, whichever basis, explain to me the appeals court's statement, okay? Well, let me ask you another preliminary question. Until your client was ordered to undertake cleanup operations, correct?
Yes.
There had been no prior claim of environmental damage or order by intent by private or state or federal party to clean up, correct?
That's my understanding.
Okay. Then help me understand at the bottom of page 483, and if you don't have it, it's okay,
I'm sorry?
of page 483 of the appeals court opinion. It says, to the extent that Nice controlled Salem, it may be reasonable to infer, and let's assume there was pervasive, quote, control, I'll go along with that it set the policies for Salem Gas with respect to identifying, investigating, or responding to the contamination caused by its operations, past and present. There was nothing in the past, was there? In other words, there was nothing that Salem was being required to do that Nice was interfering with what it should have done. Am I correct?
Well, I'm having trouble following the
Okay.
part of the opinion,
In the piercing the corporate veil context, it seems to me perfectly reasonable that when you've got an operator operating and causing hazardous waste, and I think that's why you want to push on the operating side, and the parent is essentially telling the subsidiary operator what to do, courts don't mind piercing that corporate veil because they're essentially saying, looking, they're continuing, they're not cleaning up, they're dumping, they're causing all of this environmental damage. When you have an owner, even if there's pervasive control, the pervasive control is not impacting in any respect decisions that the subsidiary is making as a former owner of that's my question.
I can answer that.
Okay.
We have to start with the idea that the owner has continuing liability and an obligation to clean up the mess. If you don't accept that, then the rest of my argument isn't going to go anywhere.
Nobody knew that there was a mess.
It may be that no one knew that there was a mess, but it's fundamental law that 21E is retroactive. I mean, the liability...
No, I understand all of that, but when I'm piercing the corporate veil, which we don't normally do, if you've got a successor, that's different, but if you don't normally, you don't do it on a piercing the corporate veil basis. Because there's no control that the parent is exercising. Otherwise, we would simply say every parent company is going to be liable for every former owner, where the subsidiary was a former owner. And that would be it strikes me as a radical departure.
Well, let me point out to a couple of things. I see my time is running low, so let me try to get these points in here. First of all, one thing I think that's an important point is that while there may not have been known specifically that there was contamination on the property, it was known back when Salem Gaslight owned the property that what it was doing to the property was creating a danger. There is a report in the record that talks about what was known about the hazardous waste situation in the manufactured gas industry at the time.
But what did Nice do that tried to conceal anything or subvert any of this knowledge from percolating to public view?
Well, that's I don't know, but that's not our claim. Our claim is this, that Nice exercised such control over Salem Gaslight as to effectively become Salem Gaslight.
So is this a piercing the corporate veil issue, or is it a subsequent apparent owner?
It's an alter ego issue. It's an alter ego issue. Let's start with the fact.
But you're not alleging any fraud or misconduct on the part of Nice.
I don't think that we need to.
Okay.
I don't think that we need to, although I think it's relevant to know that at the end of the day, the North Shore assets, which consisted also, well, North Shore at some point, North Shore becomes liable on the debt as a result of the consolidation without any question whatsoever.
And that would be true in any parent-subsidiary relationship.
Well, North Shore at that point isn't a parent of anything. It actually has absorbed Salem Gas with its liabilities. But at that point, Nice then goes and essentially sells the assets of North Shore. Rather than putting the money into North Shore, it holds the money. Now, the amount of money that it got was a lot more than what this environmental cleanup would cost. And that's what they were the points that the appeals court made here. Rather than going and seeing to deal with cleanup issues or at a time when it was known that there was a possibility, they may not have known it, but it was known, they pocketed the money. Now, here's one of the...
Wait. That was the point of my question. There's no claim. At the time that the parent, whoever we ultimately decide is the parent here, is acquiring or making demands on Salem,
The problem becomes one of the very nature of Chapter 21E.
oh, I know.
The problem is...
Nobody understands that if you sold property 100 years ago, you may be liable.
Well, that's right. And
But the question is, who?
Here, and if I can just try, I see my time's running, if I can just try to address that point really quickly. The fact of the matter is that if Salem Gaslight, if we weren't talking about Nice and weren't talking about North
If
Shore
you're talking about
Gas,
Salem Gaslight,
Salem Gaslight still existed today.
it's on the hook.
Even if it didn't know about
It's
it.
on the hook.
That's right.
Nobody ever
Now-
believed that, but that's what CERCLA says.
Okay.
It's on the hook.
Exactly. Now, North Shore Gas would be on the hook under this scenario because it assumed all the liabilities. Salem Gas was consolidated into North Shore Gas, so that today North Shore Gas, even if it didn't know what was going on, by going and being the entity to whom this Salem Gaslight was consolidated, becomes liable even if it didn't know about it
Mr.
before.
Bodoff, are you saying that the appeals court's decision on piercing the corporate veil is a sort of frolic and detour? Because there's a whole body of law that you can't even get to piercing the corporate veil unless you've got two distinct entities, a parent and a subsidiary, or two subsidiaries. Or I mean, we can go up and down. We've done it a variety of ways. But you're saying they're one?
Well, certainly North Shore Gas and Salem Gaslight in the legal sense were one entity. North Shore Gas and Nice, in the legal sense, were separate entities, but Nice exercised such pervasive control over Salem Gaslight, and all of this is detailed in the record. I'm not going to have time to go through it right now, as to effectively become North Shore Gas, or North Shore Gas becomes it. And when you go and you take a look at the liability that 21E imposes, whether it's a strict liability statute, whether or not you knew of the problem, then if you come to the conclusion that Nice's exercise of North Shore Gas was enough to effectively make them one and the same, then the rationale of Chapter 21E imposes the liability.
Is that apparent from the language of the statute?
Yes.
Yes.
Yeah, and there's, I don't think there's a Massachusetts case specifically dealing with it, but there's a host of cases under CERCLA
Yeah.
that also deal with the retroactivity part of it. Another point to keep in mind is the fact that the end result of all this is that the entity that is is the one who ended up with the money right now is saying, we don't want to be liable for this, yet the entity that everyone's pointing the finger to as the one that should be liable, Salem Gaslight, has been stripped of its assets. Now, I'm not saying that there's anything wrong with it, the money having gone to Nice, but it having been the recipient at the end of the line for all of this becomes liable.
To some extent, I don't buy that, because if the company had been sold off in 1910 and been stripped of its assets, we would face the same situation.
There's a difference between what happens if a company becomes insolvent for other reasons, but when the assets themselves are traceable to another entity, I think the situation's different.
Thank you, Mr. Bode.
Thank you.
Mr. Kirsch, so we're going to stick on piercing the corporate veil.
Yes, Your Honor, Robert Kirsch with Tina Wu for National Grid, and I'd like to address the corporate veil piercing analysis of the appeals court, and if I have a minute at the end, a question on the issue of fees and the shifting of fees under the statute.
Sure. Can I mean, you understand where I'm trying to press, which is we have, in essence, what's a strict liability. As I understand the plaintiff's argument, and I'm not trying to put words into Mr. Bodov's mouth, but I want to see that I understand his argument, and you tell me if you think I've got it wrong. He can also tell me that. He's, in essence, saying this is a strict liability statute. I'm leaving aside the operator piece. I'm just doing the owner piece. This is a strict liability statute. Therefore, if you have two entities, parent and subsidiary, or it could be subsidiary to subsidiary, but two separate corporate entities that we generally treat as entirely separate, if there is significant control of the parent over the subsidiary for whatever purpose, just significant control, not because this is a strict liability statute, therefore the parent is liable under 21E. Do I understand his argument correctly?
That's what he just said.
That's what he just said, Your Honor.
Okay. Why is he wrong?
Well, in the Martignetti-High-Far decision, this
Right.
court established that the 21E liability scheme did not displace the standards of corporate liability that had been in place in the Commonwealth for many, many years, and which remain in effect today. And
Yes, is there an estimated cost for cleaning this up? Has
We don't
anybody
know.
ascertained that yet?
we don't know, Your Honor.
Okay.
This case has been limited to the successor and
All right.
veil-piercing liability arguments.
So is it your understanding that that Chapter 21E is different than CERCLA with respect to the liability of a parent corporation just by virtue of its status as being a parent corporation of an offender?
No, I believe, Your Honor, that Chapter 21E and CERCLA are similar, and the Best Foods decision 1 year after this court's High-Far decision really laid down a similar veil-piercing analysis and adopted the identical reasoning that this court did in Martignetti for distinguishing among separate corporations.
So to continue, if there was an operator claim here, then you would be looking to the nature of pervasive control, correct?
Correct.
This is an owner claim. I mean, unless we decide that there's an operator claim, which doesn't seem to me to be the case. Then to what do I look to decide whether or not the court should pierce the corporate veil?
The case law has been consistent, Your Honor, and that you would look to the traditional factors that have been adhere to in the Commonwealth, the 12 factors that are laid out in the Pepsi-Cola decision, whether there was intermingling, adequate capitalization, et cetera. And in this instance, there was no such intermingling. There was no pervasive control. Certainly not at any time that there was an opportunity for the parent corporation to influence the conduct of the subsidiary
Well,
corporation.
that was really what I was pushing him on.
Yes.
So if I look at that, well, are you conceding that there were some times where there was pervasive control, like when the SEC was making its findings?
I'm not conceding that, Your Honor, but I think it's not necessary for the analysis
Because
this
if I
morning.
look at that period of time, there was no claim as
Absolutely.
an owner.
At that time, there was no duty, either statutory or regulatory, on either Salem Gas, which had been responsible for the contamination, or on its immediate parent or any subsequent parent. There simply was no statutory or regulatory duty either to investigate or to clean up contamination at any time that National Grid or its predecessors had any interest in either Salem Gas Light Company or North Shore.
Again, I'm not trying to put words in your mouth, but I'm trying to make sure that I understand the argument. So, looking at the appeals court decision, would I be correct in understanding that you would say where the appeals court took a slight wrong turning was when it starts to talk about piercing the corporate veil, it's looking at, quote, active and direct participation by the representatives of one company exercising pervasive control, but it's not looking at whether there was any duty, obligation, requirement, statutory or other for the subsidiary to be doing anything at that time.
Precisely, Your Honor. The court ignored that, which we believe is a necessary precedent, and it also seemed to adopt the reasoning that it could pierce the veil for reasons of supporting public policy alone, and there is no basis for that in the law of the Commonwealth. And
No, I understand, but it seems to me as the appeals court structures its decision, you make the first, what I would say, is potentially an incorrect step, and then you can get to talking about public policy. In other words, if step one is correct, it may not be incorrect to look at public policy. If step one is incorrect, you can't shoehorn it in through public policy.
yes.
Okay.
Can I ask a question just to make sure I understand some of the sort of the status, particularly in 1973? Do you agree that North Shore and/or Salem have the liability here?
We believe that Salem had the liability,
All right.
Your Honor.
The other side says that it was consolidated into North Shore. Therefore, let's assume for a moment that North Shore has the liability. In 1973, you owned North Shore, right?
Yes.
Some large 97% or whatever it was, or maybe 100%, I don't know. You own North Shore.
We own North Shore, majority.
You sold the assets of North Shore.
We sold the stock.
You sold the stock. You
Yes,
didn't
sir.
sell the assets.
did not
And then
sell
I
the assets.
misunderstood the previous. You sold the stock to North Shore. So who bought the stock? Boston Gas or Eastern Gas to Boston Gas?
I regret that we didn't bring the chart that we used at the summary judgment argument. The liability.
Is it in the
remained-
record? Was it marked?
I don't recall, Your
big?
Honor. It was big.
Do you have any objection if the chart is produced to the Supreme Judicial Court, Mr. Bodoff? And you can produce your own chart, too. I don't have a problem. Okay, thank you.
It was relied on by both parties at the trial court level.
So basically, you sold the company. So I misunderstood for some reason, and that's why I was
Who did you
confused
sell it
reading the
to?
briefs.
We sold the stock to Eastern, which sold the assets to Boston Gas.
So the liability, assuming it's with North Shore as the successor to Salem, the liability when you sold the company went with North Shore to Eastern.
It remained in North Shore or Salem Gas Light.
But Eastern now owned North Shore.
Eastern, North Shore was a subsidiary of Eastern at the time, but they were separate corporate entities. North Shore was dissolved in 1980, I believe, and Salem Gas Light
So
Company
at
was
some
dissolved
time,
in
somebody
1988.
sold the assets of North Shore.
Yes. All on the same date. December 20th, 1973, we sold the stock to Eastern.
Eastern.
The same date Eastern sold
And
the
that's
assets
the
to
date you
Boston
said,
Gas.
that's the date you got out of this whole problem.
We thought so, Your Honor.
Well, it
Okay.
has to be 1973.
And that certainly predated CERCLA or Chapter 21E or any of the regulatory or statutory duties that might have motivated
Your position
inquiry,
is,
Your Honor,
your
as asking
position
about.
is very simple. In 1973, you sold it to Eastern Gas and Boston Gas, lock, stock, and barrel, because the stock took the whole company with it. At that time, the statute didn't exist, and that's the end of that.
We believe that that is a sufficient analysis, Your Honor. And
What else?
if I could spend one moment on the fee issue and
Sure.
yield to Mr. Pence. The fee-shifting provision in Chapter 21E is intended to protect parties like National Grid from defending claims based on unclear facts and legal theories that lack a reasonable basis. The trial court's decision here suffers from two compounding legal mistakes. First, Judge Van Gestel determined that the Chapter 4A process was optional, and that's simply not correct under this court's decisions. It's mandatory. Second, and because of that, he applied a more lax level of analysis to the interchange between the parties and the information exchange. Second, he applied a 12b6 standard, essentially finding that as long as there was any basis for a claim at all, rather than any reasonable basis for a claim, that the plaintiff should not be charged with the fees of National Grid. And I would submit that if this court were to revisit the standards and the facts of this case and apply the appropriate legal standard, I cannot think of another case that would call more for a remand for determination of a fee award.
Thank you, Mr.
Thank you.
Kirsch. Mr. Pence, good morning.
May it please the Court. Marty Pence for Boston Gas Company and Keyspan New England, LLC. This is the successor liability part of the case. I'm going to try to leave a minute, if that's possible, to discuss the fee issue from a different perspective, but let's talk about the successor issues. The trust says that Boston Gas succeeded to the liability arising from the Northeast Street Gas Works when it purchased the assets of North Shore Gas in 1973. The Superior Court and the Appeals Court rejected that contention. The starting point is that Boston Gas did not expressly agree to assume the liability. As the John Boyd case held, same exact transaction, different one of the three subsidiaries that was sold, same transaction. It was clear that Boston Gas picked up only accrued and not contingent liabilities. Under the asset purchase agreement, Boston Gas agreed to assume liabilities of North Shore only as then existing. Under the assumption for liabilities, which was given at the time of the closing, it was only liabilities outstanding at the date of the closing. So there was no express agreement to pick up these liabilities that would arise only 10 years later than the transaction in 1973, when in 1983, Chapter 21E was passed. So the trust offers really essentially two alternative arguments for successor liability. One is under common law successor liability doctrine, which many judges have found to essentially have merged two concepts, the de facto merger and the mere continuation concept together. Let's talk about this deal. It is important to understand both the technicalities of the deal that was done and the big picture of what the deal creates, because I think various justices have correctly characterized it, but it is important to understand that. So Nice sold the stock that it owned, virtually all of the stock in these three subsidiaries.
Excuse me, Mr. Pence, and I may be way off base here. You prevailed in the appeals court, didn't you, on liability issues?
Yes.
Did Mr. Bodoff seek further appellate review?
Yes.
It was granted on all aspects of this case.
Yes, Your Honor.
Okay.
So we think we have to address this. If we don't
I'm
need
sorry,
to, we're happy.
No, I think you have to address this.
I was relying on Mr.
The FAR
Kirsch.
wasn't limited in any way.
I was relying on Mr. Kirsch that on applications from Keyspan and National Grid, this court granted further appellate review.
Well, we made the application on our cross appeal on the fees issue,
Okay.
which hopefully I'll get a minute
So
to
Mr.
talk about.
Bodoff appealed this, okay.
All right. So the stock of each of these three subsidiaries sold to Eastern same day. The subsidiaries themselves, not Eastern, but the subsidiaries themselves sell all of their assets to Boston Gas Company. The reason all this had to happen is because the minority interests, this last 3%, needed to be removed. This was a requirement of the federal government relating to the divestiture background that the court heard earlier. So it had to happen in 2 steps. But essentially what happened was on the 29th of December of 1973, Nice had 3 subsidiaries. And then on the 30th, it had more than $27 million, and Boston Gas had the assets of the former subsidiaries. So looking at it that way, looking at the deal as a whole, which is what we do when you're looking at successor liability doctrine, the concept is stand back and get a sense of what the substance of the deal was. The whole idea is that we're not going to look at formalities, but substance. And the substance here is an asset sale. And that's how John Boyd looked at it. That's how both the Superior Court and Appeals Court looked at it. And what do you find? 0 continuity of shareholders. Nice before, Eastern after.
But hold on. So where did North Shore go? The company that sold all of its assets
Was North Shore.
was North Shore.
They went out of business.
They got how many millions of dollars for it?
Well, the
Eastern.
stock was, the stock sale got Nice $27 million.
Yeah, but we're talking about the asset sale now. You say you
Right.
just bought the assets. So Eastern or somebody now owns North Shore.
Right.
They've acquired the stock of North
So
Shore.
Eastern gets the
North Shore
cash.
sells you the assets. North Shore gets the dough.
Right.
So where does it go?
To Eastern, and then it gets contributed back into Boston Gas Company.
So you end up with the money and the assets of North Shore.
No, not all the money.
Well, virtually all of it. 3% or something for other shareholders, or
But Eastern, of course, had to pay $27 million for the right to end up that way. So it's a wash in that sense, that cash tracking.
well, it's a wash. But we've got a company here that's liable, continues to be liable for cleanup responsibilities. It sells its assets, gets the money, and then the money goes away.
In effect, North Shore dissolved. So the plaintiff would be left vis-a-vis North Shore with the statutory remedies in the event of liability of a dissolved corporation. That is true. But with respect to Boston Gas Company, let's look at the successor liability doctrine. No continuity of shareholders. Management changed completely. All the Nice-appointed directors and officers resigned when the transaction occurred. And there's no continuity of enterprise as well, because what was a liability arising from the manufactured gas era is now just natural gas storage and distribution operations. So all of the courts that have looked at this same transaction previously, the First Circuit and the two lower courts here, have found there is no basis to impose successor liability under common law theories against Boston Gas. The other theory the plaintiff advances for successor liability posits that Section 98 of Chapter 164 of the General Laws regulating utilities compels the transfer of the liability. This was an issue that was looked at in very careful detail by Judge Woodlock in the Longview Fiber case, who essentially said, no, that statute traceable to the acts of 1908 was for the purpose of shifting responsibility for reviewing these transactions from the legislature, which had it up to that point, into the DPU. But generally, the concept was that companies could contract against the background of the common law and would not necessarily be compelled to pick up all liabilities. The phrase that the judge relied upon in Longview Fiber and also in John Boyd was the end of it, where it says that the liabilities are picked up only so far as the same are applicable to the purchasing or consolidated company. Not only does that mean that what controls here is the asset purchase agreement, but it's also important to recognize that we didn't get the Northey Street property. Boston Gas didn't acquire it. It was gone 83 years before. So even if one were to take a more expansive reading of the statute, the liabilities would not be applicable to what was acquired by Boston Gas.
Well, that appears to be what Judge Van Gestel was saying, ironically, in the attorney's fees thing when he says that the trust didn't pursue the correct successor to Salem Gas's contamination liabilities. It seems to me that is at least questionable, because if Salem had sold the property to whoever the next purchaser was, under Circular and 21E, I don't think that relieves Salem of obligations, correct?
That's true. It would not.
So I'm not sure that Judge Van Gestel, it's a footnote, it's irrelevant, I think.
What I think, I'm not sure I have the footnote in mind that you do, Your Honor, but my
But
understanding
the
was
one that
that what
says
he
it thus
was...
quite simply did not pursue the correct successor to Salem Gas's contamination. For example, who was in the chain of title to the Northeast Street property after its sale by Salem Gas? And what about the liability possibilities for North Shore Gas after some, but not all of its liabilities were assumed by Boston Gas in 1973?
Right, so with respect to North Shore Gas, you would go to the dissolved corporation route. With respect to subsequent purchasers, they too might have liability, but I would agree that wouldn't extinguish Salem Gas's liability.
Yeah.
If I may have just one moment on
You
the
may.
fees issue.
Sure.
Just to emphasize something slightly different from my brother. The key, in our view here, is the matter of good faith in the 4A negotiations. Justice Graney wanted to know how much it was going to cost to clean up this site. The reason we don't know that is because the plaintiff refused to tell us in the 4A process at the outset. We asked questions about what's going on at this site, what are the plans for cleanup, how much is it going to cost. They refused point blank. We're not going to tell you. We want to talk about liability issues. Okay, well, fine. Give us an explanation of the basis for our liability. Well, what we're saying is you can't make it go away. It's got to be you or him, referring to the two families of companies. But we're not going to tell you why in particular we think you are.
Mr. Pence, is this in the record, the refusal to in the 4A negotiations?
Yes.
Okay.
Seems to me if we could ascertain that price, and it was a reasonable price, rather than engaging in this extensive litigation with all the money that's been spent on lawyers, it might have gone away.
Precisely, Your Honor, and that is exactly the point of 4A. Thank you very much.
Thank you, Mr. Pence. We'll take a short break.